It's a report nearly 2 years in the making, and it's almost here. Special Counsel Robert Mueller could submit his findings on the Russia investigation as early as next week. But it's still not clear how much you and I will actually get to see.
That'll be totally up to the new Attorney General. He's a tremendous man, a tremendous person who really respects this country and respects the Justice Department. So that'll be totally up to him.
As Donald Trump is well aware, DOJ regulations require Mueller to submit his report to Attorney General William Barr, who must then submit his own report to Congress. But at his confirmation hearing last month, Barr stopped short of promising full disclosure.
It's very important that the public and Congress be informed of the results of the special counsel's work. My goal will be to provide as much transparency as I can consistent with the law.
The law, or actually in this case, Justice Department regulations, give the Attorney General a lot of freedom to decide what is and isn't appropriate to pass on. Not even top legal scholars agree on what power lawmakers would have if Barr decides to keep much of the report under wraps. Here's former federal prosecutor Jeffrey Toobin, now at CNN, along with the acting Solicitor General under President Obama, Neil Katyal, who wrote the DOJ regulations himself in 1999.
Well, they might not settle for it, but they may have to settle for it, because I think Barr has a tremendous amount of discretion here.
I do agree that the regulations give a lot of deference to the Attorney General. If Barr files something that is a small report or a brief report and it redacts all the information that Jeff is talking about, I think Congress will be, have to ask for everything. And boy, that could be pretty damaging to the president.
Joining me are Bruce Singal. He's a defense attorney who worked along with Mueller in the U.S. Attorney's Office in Boston. Good to see you, Bruce. Thanks for being here. Jack Cunha is defense attorney and principal with Cunha and Holcomb. Both, by the way, have been named Mass Lawyers Weekly's Lawyers of the Year. I have not been, by the way, if either of you are wondering. But that'll come, I think, in good time. Can we start at the beginning? Do you buy the notion that Mueller's just dotting the I's and crossing the T's?
I buy the notion that he's a by-the-rules guy. But it's not clear what playing by the rules would mean, given the scope of his authority. He's supposed to do a confidential report for the reasons why he has decided to prosecute or declined to prosecute somebody. That leaves him a lot of latitude in what is a confidential report he gives to the Attorney General.
In terms of being, the Washington Post had a great story today saying circumstantial evidence. The number of lawyers in his office are down. A number of the lawyers in his office have notified their old law firms that they'll be coming back soon. But I have to say, I'm amazed. He's never interviewed the president. There have been written questions and answers. No subpoena fight, which we were all geared up for. Does that surprise you that he didn't bring to a head the whole issue of the president testifying?
Well, certainly the last time this different kind of prosecutor, special prosecutor, but certainly the last time there was that fight with Clinton, I was surprised. If you want to find out what was in his mind, and a lot of what he's looking at it would bear on intent. The intent would be important. So not having spoken to him, I was surprised.
But I was 10 times more surprised, not by the president not being called, his kid. It is factually accurate that one of the critical times in this whole investigation, the infamous meeting in June at Trump Tower, Donald Trump Jr. was there. What possible reason could there be for not calling him before Mueller by Mueller?
I share your surprise, Jim, and expected he would be called, and frankly, I don't understand.
It could be because he's a target. I mean, that's what I read from some. You guys are in the practice that maybe if he's a target, Mueller has decided I have enough. I don't need to talk to him. I don't want to expose any of what I have to him, so I won't even call him.
Well, here's the other thing. As tight-lipped as Mueller is, how do we know he hasn't been talked to behind the scenes and interviewed without it's being publicly known?
Well, that's possible. There are also, another Washington Post story I found really interesting, there are a ton of sealed indictments that have been submitted. We don't know who submitted them or about whom they are, but they were submitted to the same federal court in Washington that Mueller does all of his special counsel work. Is it possible that the report gets submitted to Barr and that sealed indictments lead to opened indictments post-report filing?
I think that's possible. If that is the scenario, then it's a lot less likely that we're going to get, meaning the public, a detailed report.
Because there's so much more to go.
Well, yeah, if they're going to bring actual prosecutions, they're not going to put their evidence out.
So why
into
would
a public
he submit
report.
a report unless he's
started
the prosecutions?
I think he has to.
Well, there's no deadline.
It's mandated.
He has to when he's when he's. I don't mean ever, but I mean why? You know, this report. You started touching on this, Bruce, to begin with. We all have learned in the last few days, which I had forgotten, the Ken Starr report, which was under totally different rules, 453 pages, grotesque graphing detail about Bill Clinton. And then there was the other thing, Leon Jaworski, obviously, the Watergate prosecutor, what was called a roadmap, a Sirica's roadmap. Sirica was the judge who oversaw the thing. Based on what you know, because you had a relationship with Mueller and what you read now, what are we more likely to see, a detailed Starr kind of thing or a roadmap? And the notion of the roadmap was this is a roadmap for Congress to follow, should they choose to follow it in terms of their investigations.
I think it'll be much shorter, much more succinct. It can still be compelling in terms of his explanation for why he decided to prosecute and declined to prosecute. I mean, for example, for the president, he could outline the evidence and say, ordinarily this would be sufficient to charge an individual with federal crimes, but because of the Justice Department policy
that says
against sitting presidents, I am declining to prosecute him at this time.
But that's not binding. I mean, that is the guideline, but he's not bound by that, right?
Isn't that the catch-22, though?
Meaning what?
That the DOJ guidelines say you can't indict a sitting president, and that's contentious, but that's their position. They also say, and for good reason, you generally do not publicize facts if you're not going to indict somebody. So,
but that's when there's, to use the word declination. This would not be declination. This would be maybe I would have prosecuted, but I can't because of my own rules.
Right, but that's Barr's choice
about whether to proceed with this thing.
Exactly.
Well, you know, when I'm watching Jeffrey Toobin, who I have to say I have a bromance with from afar on CNN last night, I'm sitting there saying we can end up with a Post-it note when Barr is done. Here are the regulations, by the way, that I referenced a minute ago. The key line: the Attorney General may determine that public release of these reports would be in the public interest. Here's the key line that he referred to in his testimony: to the extent that release would comply with applicable legal restrictions. There could be executive privilege. There could be security concerns. We could end up literally with a piece of paper, couldn't we?
We could end up with a very small piece of paper, because that language you're referring to, Jim, does not refer back to Mueller's report. Mueller does a confidential report to Barr. Barr then reports to members of the Judiciary Committee an explanation of each action that was taken. And that would be, in his own words, as succinct as he wants to make it. And it's only that very narrowed set of reports or summaries that he does, which is subject to the language you talked about. And don't forget, he's got plenty of leeway between executive privilege, classified information, grand jury secret information, to eliminate information that is harmful to his master, who's the president.
Oh, well, that's a real question. You know, we had a long discussion with Chuck Todd from Meet the Press today about his, as you call him, his master. And I speaking for Marjorie Egan and Chuck, my coworker, and Chuck Todd, they both think, and I subscribe to this guy's at the end of his career. And he is unlikely, they don't know him, you guys may, unlikely to be as beholden to Donald Trump as, say, Jeff Sessions was early on. Because, you know, what does he have to lose except his own integrity?
You would hope that he'd see this as an historic moment.
Right.
And, I mean, I think that's what you're addressing.
Well, also I'm hoping.
Yeah.
I mean, I don't know what the outcome's going to be. I want it to be honest. I mean, I should put the poll up. A CNN poll, this is not surprising, I don't think, at all, 87 to 9%. You guys know, that's essentially everybody in the country wants the full report out before the people.
And that's the real question, because this is a political moment more than anything. We're talking about it as lawyers, but it's really a political moment.
Well, there's a legal moment, too. What power does Congress have? Let's assume that Barr doesn't disclose much, that single page or whatever we talked about a minute ago. I assume Congress can subpoena the report, what happens. I assume Congress can subpoena Mueller What happens in either of those
I wouldn't
circumstances?
assume that they can successfully subpoena, because the motion to quash that would greet the subpoena would be subject to the very restrictive language in the regulations. And when I say restrictive, it gives Barr great leeway to decide how much or how little
And a
he
court
wishes
might
to
defer
choose.
to that.
Well, a court, I believe, would. That's the governing standard in these regulations.
But that's why I say it's a political moment.
Meaning
Because
what?
because his discretion, how he exercises his discretion is really a political decision. What is it that he feels is appropriate to reveal? And he clearly can reveal little or a lot.
Well, he can be challenged too, I assume, under the regulations.
Yeah,
can he
but
not?
when it's a discretionary decision, it's very hard to challenge.
One last thing, for those who are sitting at home saying, I know this is going to be horrible, regardless of what side you're on, we're going to hear nothing. There are the prosecutions of the investigations of the Southern District of New York into the into citizen Trump's finances and businesses, into the inaugural committee and the $100 million they raised, much of which is unaccountable. Executive privilege and those national security can't be claimed about those behaviors from when he was a citizen, can they?
No, in all likelihood, no. But that raises an interesting point, and that is that the information that the public has this pent-up yearning for may be able to be obtained through sources other than Mueller's report or Barr's summary
Like
of
the
Mueller's
Southern
report,
District.
like indictments. Now, Mueller may still have indictments in his
And he has
query.
disclosed a lot in
And
those
his
pleadings
indictments have been extensive, what we call talking indictments, speaking indictments, that reveal a great deal of detail. He may recognize that he's limited in terms of what he can ensure gets to the public through his report to Barr, but that he can get it to the public by very detailed indictments.
Don't
or
forget,
others.
one of those lawyers or judges you deal with said once sunshine is the best disinfectant. Can we all agree?
Yes,
Yeah.
sir.
Unless it's your client. Goodbye. Nice to see you,
Right.
Jack.
Good to see you,
Jack.
It's a
Thank
pleasure.
you.
Good to see you
Okay.
both. Thanks so much.